Hello everyone. Today we would understand in detail the procedures adopted with respect to child in conflict with law under the Juvenile Justice Act. We begin with understanding the meaning of child in conflict with law under the Juvenile Justice Act. A child in conflict with law is a child who is alleged or found to have committed an offense, who has not completed 18 years of age on the date of commission of such offense. By virtue of Section 6 of the Juvenile Justice Act, the age of the juvenile at the time of commission of the offence is relevant, and not the date on which he was apprehended or the date of his conviction. Now, understanding the procedure under Section 10 of the Juvenile Justice Act, which need to be followed when a child is apprehended. Such child shall be placed under the charge of Special Juvenile Police Unit or designated Child Welfare Police Officer. He shall be produced before the Juvenile Justice Board within 24 hours. A child shall not be placed in a police lockup or lodged in a jail in any circumstances. Rule 8 of the Juvenile Justice Model Rules 2016 provides that FIR can be registered only in two cases. A heinous offence is alleged to have been committed by the child, or when the offence is alleged to have been committed jointly with the adults. In other cases, no FIR shall be registered. Now coming to the procedure when child apprehending is not necessary. In such cases, the Special Juvenile Police Unit or the Child Welfare Police Officer shall record the information about the offence in Journal Daily Diary and the circumstances under which the child was apprehended. Then he prepare a social background report of the child and forward both to the board before the first hearing. He also intimate the parents or guardian of the child as to when the child is to be produced for hearing before the Juvenile Justice Board. Now coming to the procedure where the child is apprehended by police. In such cases, the police officer shall place the child under the charge of Special Juvenile Police Unit or the Child Welfare Police Officer, who shall inform the parents or guardian about the apprehension of the child and the address of the Juvenile Justice Board and the date and time when they need to be present before the board. Inform the probation officer to obtain information regarding social background of the child to be presented before the board. The police officer who is apprehending a child alleged to be in conflict with law shall perform the following actions. First, he shall not send the child to a police lockup. Second, he shall not delay the child being transferred to Child Welfare Police Officer from the nearest police station. He shall not handcuff, chain, or otherwise fetter a child and shall not use any coercion or force on the child. He shall inform the child promptly and directly of the charges leveled against him through his parents or guardian, shall not ask the child to sign any statement, and inform DLSA, District Legal Service Authority, for providing free legal aid to the child. Once the child is produced before the Juvenile Justice Board, the board shall review the report containing the social background of the child, the circumstances of apprehending the child, the offence alleged to have been committed by the child, and may pass order in relation to the child at it deems fit, including orders under Section 17 and 18 of the Act. The Juvenile Justice Board may dispose of the case if the offences are petty or remain unfounded. It may refer the child to committee where it appears that the child is in need of care and protection. It may release the child in the supervision or custody of fit persons or institution or probationary officers. It may direct the child to be kept in child care institution if necessary during the pendency of inquiry. Now coming to the timelines. In all cases of release pending inquiry, the board shall notify the next date of hearing within 15 days of the first summary inquiry and to seek social investigation report from the probation or child welfare officer. In cases of heinous offences alleged to have been committed by a child who has completed the age of 16, the child welfare officer shall produce the statement of witnesses recorded by him, other documents prepared during the course of investigation within a period of 1 month from the date of first production of the child before the board. In case of petty or serious offences, the final report shall be filed before the board within 2 months from the date of information to the police. This series would be continued further to explain other important aspects of juvenile justice in detail. This would be helpful for all the individuals, including professionals in legal field. Do continue to watch this series and share your feedback by way of comments.